If you have prayers for this one, please give it to the podcaster. You will make some adjustments and take it out. Yes. Three zero. Okay. Both sides are represented. Mr. D. Mazumdar, Additional Advocate General for the state, submits that an affidavit in opposition by the detaining authority has been filed, which is not on record. He also submits that the other respondents will be filing. He prays for some further time for filing of affidavit by respondent number 2. So, next, accordingly, matter stands adjourned today. List on 26/8/2025. So, advance copy of the affidavit shall be served on the learned counsel for the petitioner by email. We don't know. We can't assure you. We'll try to take it up, but in my cost title, cost list, you'll never find time. We may accommodate, but no time, no assurance. I would not bind myself. No, it's okay. Item number 32, 33. Okay, we'll try to. Inquiry about? Okay. $38. Okay. Item 3 for 2 weeks. It's a motion matter. Okay, give a fixed date. It's a 2019 motion matter. 3 for 2 weeks. It's a motion matter. Give a fixed date. It's a 2019 motion matter.
Okay, item number 34, the petitioner is in detention. Can it be approved?
Item number, I have two options similar to the other. 32. Tabulated.
Wait, please, Your Lordship. Lordship, item 45, I'm paying for upgrading the same because is first item after motion. Because, my lord, I have been declared foreigner without giving any notice, my lord. Interim order is not there, my lord. Yes, first item. 45. I'm
May I plead your lordship, I beg to mention item number 26, my lord. Lordship, matter may be adjourned for a week, my lord. 26. My lord. Oh, my goodness.
Lordship, I beg to mention item number 25 for adjournment. Yes, Lordship, item number 25. Obliged, Lordship. Ah.
Item 1 for motion.
Record to line.
Item 1 for motion.
Okay. None appears on call for the petitioner. All the respondents are represented. Next paragraph, for Angel Justice, the matter stands adjourned today. List again on 208/2025.
Item 2 for motion.
Please, Lordship. Lordship, Mr. Z Ali is the conducting counsel of this case and the brief is with him, Lordship.
Pardon me?
Mr. Z Ali, who filed this instant case, Lordship, and the brief is with him. Initially, I assisted him for some time and subsequently in a written note, I told him I will not be able to continue with you in this instant case. So, Lordship, my name will be back up from the instant.
No, no, no. File an application. It can't be struck off like that. Names of the council cannot be struck off like that. You follow the rules. You do whatever is required under the High Court rules and then make a prayer. You adjourn it for a week, you take it up on 20. It's between you, what you do. Both sides are represented on the prayer made by Mr.
M. Islam, Lordship.
M. Islam, and counsel for the petitioner. Matter stands adjourned today, list on 208/2025.
Item 4.
Lordship, the matter will be possible for that being Lordship. My senior is at Lex.
Okay. after some.
Item 3 is called, I suppose. Item 4. One. I'm sorry, Your Lordship, I was at late. Lordship, here an ex parte judgment was passed against me. At page number 23. Annexure 3. Initially, a WS was filed by the proceeding. However, there was concurrent non-appearance on the part of the proceeding, Your Lordship. It was filed, it was passed on 9/5/2016.
What is the explanation?
Lordship, thereafter, the son of the proceeding filed a petition to set aside that, Your Lordship. Before the tribunal, it is at annexure 4, page 26, Your Lordship. And the proceeding, the son filed it because the proceeding was a schizophrenic patient, Your Lordship, and there was a house burn. And all these things came down, and then the son had to interfere and file the petition on behalf of the mother to set aside the ex parte. That was decided by the order at page number 31, annexure 5.
Ms. Verma? I think this can be covered by your scheme.
Yes, Lordship.
Can I speak to him and
Yes, we the price of the motion. For the car. It is in the community. Let him take some time, Lordship, we will give him the notification. Then we will-
okay, both sides are represented. On the prayer made by Mr. BJ Mukherjee Kamara and the counsel for the petitioner, matters is adjourned today. List on 27/8/2025. No, it is already available. Ms. Verma,
Yes, Lordship.
this we have already considered earlier.
If
What
it
happened, we don't
was
know.
Considered, Lordship, we
No,
have
no.
a mo-
Please, sorry. Does it?
we can also take a complete- no, no, no.
I think last time when the matter reached the court, this was deliberated upon. You have not taken steps. If not, then
I think
We of Nepali community, Your Lordship. That
Yes.
was
see, we have an instruction. That
My lord. India never will applicable in this case. India never, if he
849
falls under Gurkha community law.
no, we understand, but something has to be done.
Yes, lord.
you can approach
So it has to be
the.
taken.
But I have taken instruction that she married to a Gurkha person. She was not initially.
But
Gurkha.
then also they come under the.
We don't know, I don't apply our mind right now.
I may approach the authorities in the meantime if some time is given.
If this is not okay, we will apply. Also can give him some more time, Lordship.
some more time,
That I may approach the authorities.
okay, then 3rd of September. 3rd of September then.
I had only furnished this to the court lordship. So many matters we forget, lordship.
I just have a bad habit.
Lordship, actually, what had happened? My,
No, we understand, but
Yes,
we
it
don't
was-
say anything.
because here it is written, I just saw it.
That's it. Next.
Item 5,
Worship. Order dated 4/4/2024. Matter was card worship and fixed for order worship.
No, we have no difficulty. If you want us to rely on the argument made before another bench, we know what has happened.
Just
I follow the old tradition of walls have ears.
I just mentioned it.
No, it's okay, and we know, we are aware of it.
That
But
I-
we follow that old tradition of walls have ears.
No. That fixed for another date. Your Lordship.
You want another date? Okay, tell us. Okay, both sides are represented on the prayer made by learned counsel, by Mr.
Yeah, Hussain.
A. Hussain, learned counsel for the petitioner. List on 20/8/2025.
Lordship, maybe pay for a copy because all these files had already sent off for disposed files. We
Okay,
don't
give her
have
a copy.
now. Two weeks, huh? Last week we did never.
item 6,
Yes.
My lord, actually matter to come for hearing, my lord. Yes, the motion is.
No, this, you see, these are old matters and therefore it will be coming here only.
I am ready.
Because
Otherwise, this is supposed to
incidentally, in
become
this
for-
case, I think notice of motion was never issued.
Lordship, maybe pay for a copy of the petition and
Or you don't have a copy.
very short date, Lordship, maybe next week, Lordship.
Okay, give her a copy then. He has lost it.
For the state.
Perhaps his case is that all the evidence were not considered, right?
My lord, there is, my lord, my points is there, 3 points are involved.
Give her a copy.
My lord,
Both sides are represented. Yes, A. Verma and counsel for the standing counsel for the NC for the FT matters. As requested the learned counsel for the petitioner for a copy of the writ petition. So that the same be provided in course of the day today. List on 2/08/2025. You just tell her what are the 3 grounds, so she'll be prepared on the next date.
my lord, may pray for another date, my lord. Accept
Another date,
Another date.
22nd. Just tell her the 3 grounds on which you are building up your case. She'll be prepared.
item 7,
Yeah.
Huh?
It will.
कुछ लिखा ना है मैं कॉपी देखूँ
अच्छा, ये तो बात ज्यादा पढ़ना दिन से पढ़ने में कितनी होता है तो वो टाइम में बात कर सकते हैं
मिली जाए यदि मिली जाए मैं किसी जाना कितने लाख मैं प्लीज लॉर्डशिप
Because feedback used for my job, you can do at least. Just to take the feedback.
मैं प्लीज
Lordship. This may also be considered under the Citizenship Amendment Act, Lordship. My pen can seek instructions from the client.
My lord, in this case, my lord, earlier it was disposed of on 11/3/2024. Matter was remanded, but we don't get the document. Yes.
In fact, it's a blessing in disguise for him. Instead of going back, they can now consider the. I have told him, I have previously told you about the amendment act. Told him about this.
No.
And in case they still want to do, I require a copy because. Photocopy has to be taken. Up to 2 weeks worth.
Plus,
It has fixed a date for September 3rd.
part of September.
Item 990.
Item 8.
Lordship, will pass over the speaker for the time being, Lordship. For the time being, Lordship.
Finding, okay. Here, Ms. Rama, you please go through the records. Records have come, I think we'll require it.
Already heard, this matter had a hearing done.
We understand, but
Again, do it.
about this next 10-15 days, all these matters are again coming up. So the records are there. You can refresh your memory and then.
Item 9 for motion.
All these matters would be coming as top of the list.
May I please, kindly pass the matter for timing?
Time being.
Instructions are there, Lordship.
Whereabouts?
You have the instructions. 9. Don't put time now. Because you have the instructions here. It is still,
Item 9.
you only want to know where they are. No, we will give you.
Okay, since the person is at holding center, we give you
Fine.
visitation right.
My lord.
We give you visitation right.
Visitation right.
My lord, yes, my lord.
Item 9. Is that order of visitation right? Huh? But Mr. A.R. Sigdal, learned counsel for the petitioner, with the names of all the other respondents, by order dated 7/8/2025, this court had directed the Learned Standing Counsel for the FT matters to obtain information as to the whereabouts of the husband of the petitioner, just give the name first, of Sonali Ali, alias Sonali Sheikh, the husband of the petitioner, as to where he is presently lodged, if not already deported out of the country. Full stop. Accordingly, the Learned Standing Counsel for the FT matters has produced a copy of written instructions received from the Senior Superintendent of Police, within bracket border, bracket to Kamrup, Hamingdown, dated, communication dated 11/8/2025 by so and so, thereby informing that Sonali Sheikh alias Sonali Ali, a declared foreign national in GFT within bracket R, bracket close, case number 413/2017, wide opinion dated 12/1/2018, was taken into custody on 25/5/2025, and he is currently lodged at the holding center, Kokrajhar, 7th AP Battalion, Saraikula, Kokrajhar. Next para, on such disclosure being made, the court is inclined to grant the petitioner, namely Saleha Khatun, along with one other person, visitation right to the detained person, namely Sonali Ali alias Sonali Sheikh, who is currently lodged at the holding center under 7th AB Battalion, Saraikula, Kokrajhar. Next para, on production of a certified copy of the order, the in charge is capital IC, in charge of the said holding center and having custody of Sonali Ali alias Sonali Sheikh, shall permit visitation right to the petitioner and one other person accompanying her. Most of the said authority shall also allow the petitioner to obtain signature of the detained person in the Wakalatnama to be duly identified by the said official. Next para, on the next date of listing, the Learned Counsel for the petitioner shall inform the court if the visitation right has been allowed. Next para, list on 27/8/2025. Communication so produced is written on record.
Lordship, this matter can be fixed for 18th KG would be appearing in this matter.
Let it finish, because if there are too many matters again on 18th, we already have fixed matters.
27.
Once
Whatever.
whatever order is passed in one matter, we'll
28, Lordship has fixed.
27/8. Because since we are allowing visitation, Mr. Sigdal can inform us whether that has been permitted.
Item 10,
Yes.
This opinion dated earlier also guided me to, the cost title so available in
You've done it?
file minor. Yes, you have done it now. In respect response number 5 in the
Okay,
district commissioner.
okay. This is,
Opinion page
this,
72.
Verma, we are granting him bail 25 opinion. For Mr. FKR Ahmed, and counsel for the petitioner. All the respondents are there. Next paragraph, the learned counsel for the petitioner has submitted that pursuant to order dated 28/7/2025, the cost title has been amended. Next paragraph. Opinion is at page 72, dated 27/3/2025, passed by so and so and so and so. Thereby declaring the petitioner to be a foreigner of post 25/3/1971. Notice return within 4 weeks. Extra copies within 2 days. Relevant records be called for. The prayer for bail is opposed by the standing counsel for the FT matters. Considering the projection, 10 days time to take bail of rupees 5,000 to the satisfaction of
My lord, Sunitpur. SP Border Sunitpur.
Superintendent of Police, Border, Sonitpur, Tejpur. They start for 4 weeks and they sit on.
One.
Item 11,
Hey, please, Lord. Lordship, the petitioner has declared a foreigner. White. Order
Which?
dated 15/11/23,
Page
page 58, Your Lordship.
53.
58,
Eight.
58. Your Lordship, actually.
23. You'll have to wait for some time for bail.
Yes, Your Lordship, actually she was unaware of this order. That when she came up to know about this order, then she approached the foreigners tribunal with a review petition as well as a delay condonation petition.
Where is that?
That Your Lordship will find on page 64.
54.
64.
64.
64. But Your Lordship, the learned tribunal didn't accept it, didn't want it to admit it. And and it has been insisting the petitioner to take away the petition from the foreign tribunal. And thereafter, the petitioner filed 3 complaints, one before the district commissioner Sunitpur, one before the Secretary of Home and Political Affairs, and one before the Registrar General Guwahati High Court. That are also annexed, Your Lord. Your Lordship will find those on page 77, 78, and 79. At least I should have been heard, Your Lordship. And that petition is still lying in Foreigners Tribunal, Balipur.
Ms. Verma, this is very serious.
Dr. Plata, certain instructions on this, whether, what is the exact reason, Lordship? He's making his submission. We do not know what happened, actually happened there, Lordship. Something would be on the records if it has been refused or rejected.
No, if the tribunal doesn't accept, there will be nothing on record.
Nothing, no tickets, nothing.
But this is just a mere statement, Lordship.
I understand, but what else can he do?
Doctor, we will.
Either you
call up the
permit-
member and-
Either you,
Exactly.
no, either the Home Department should permit every litigant to come there with video recording of whatever is proceeding is going on. Otherwise, nobody will have any proof. This is something very serious.
If this has happened, but we should try to find out what exactly happened, Lordship.
Your Lordship, there are other accusations.
Everybody,
of the
everything
same.
will be covered up. Whatever is there will be destroyed.
Lordship,
The
it-
bench assistant and all,
The sides, Lordship, if a cover up has to happen, it
no,
has. to
because
be
this
good.
complaints is not, this is not a stray complaint. We get these complaints regularly.
Chip, his synopsis says that his counsel never informed him, but the counsel is not made a party, Lordship.
It's okay, this are policies.
Maybe communication lapses on my part too.
Just later, once
Think
please,
for complaint and,
there's something I do not like.
But-
I have 2 years, but I am trained to listen to one. No, we understand, but if this is so, it's very serious. And it's not only that, a complaint has been made to the Home and Political Affairs.
we will find out, Lordship, what steps have been taken. And Lordship, my honest submission and opinion is, because it's a 23 order, the council advised the petitioner to go and file a review now, so that he could obtain the bail, lordship, because if it's a continuous matter, he'll get the bail. Otherwise, lordship would have put it up on issue of maintainability and would not have given him bail at this stage. These are all afterthoughts, lordship.
Your Lordship, this order was passed on 16/11/23.
23, yes, and
At the
you,
last stage of 23, Your Lordship. And Your Lordship, I know Your Lordship, if I come to this court directly, Your Lordship had put some binding in adjudicating a matter under certiorari. So, Your Lordship, it is my right to avail.
Just a moment.
to Balipad. Is,
Ms. Verma,
yes, lord.
what we are of the considered view that whatever we saw, but under paragraph 382 of the Foreigners Tribunal order, a review is to be made within 30 days. Now we entertain this challenge to we take it as a challenge to to that original opinion. Instead of sending it back, making an inquiry, spending time, we accept this challenge to the impugn opinion. We should notice here.
Lordship, we will
But-
personally take it up with the Home Department, why it has not been accepted. Because even if the member had accepted with a small order, she could have disposed this off.
That's-
It's
that's
not
what-
maintainable, lordship.
You see, what would you see, coming from the bar, what would a lawyer need? A lawyer would only need that any court or tribunal where he is presenting himself will dispose of that petition. That's the only requirement. One should be heard and the
Yes,
matter would be
exactly,
disposed of.
lordship.
Nothing more,
Paid with lordship, we will also take this up, lordship.
nothing more.
Lordship, my petition is an incomplete petition. The affidavit is not complete, the paragraphs are not complete, the days are not complete. I do not know what we have filed there, lordship.
This was.
Do it up, do it up.
This was an office.
Yes, sir.
copy.
No, do it up, because if the paragraphs are not there, she will not be able to respond. Do it. Take a copy and
No, Your Lordship, the paragraphs are completely regard to the writ petition, Your Lordship. But about that review petition,
It is lordship, and it is also an afterthought to file a review at this stage. And the
But then it
member not
is-
accepting has put us in a bad position.
then
now,
you
so we
see-
Cannot defend it, lordship.
But then you see, then I can understand what has happened now. If it is not filled up, please come to page 71. Or rather, come to page this 64. That is your application, correct? It has got court fee stamps. Therefore, we have to presume that this is the original one. This is the first copy, correct? Mr. Hussain?
Your Lordship, this is the office copy that used to be with the advocate.
Then page 64 will not have a court fee stamp. You see, I've been there where you are standing. When I file a petition, I would give a what you call a court fee stamp
Right.
on the first copy and give it to the court. I don't know about others, maybe somebody is doing it, but I would not keep a court fee stamp paper for myself.
Maybe your lordship. we
Page
had-
69, Lordship will
So,
see.
as you see, I'm not over yet. Now, this page 69, the date
Verification
is not filled up.
date is not there, Lordship.
Next is 70.
It is incomplete.
In 70, the notary has signed on 17/6/25 without any paragraphs being verified. Then it's not a correct copy. Come to page 71, containing the days of so and so delay, that is not filled up.
Exactly, Lordship.
Then come to again page 73, number of days of delay is not filled up. 74, same thing. 75, verification not filled up. 76, the affidavit is not verified.
That's true.
No, we accept this as challenge to the opinion. We don't make an inquiry here. If it is not filled up, not filled up. No court will accept an incomplete. If you don't fill up an affidavit and my registry refuses it, I can't make an inquiry. Heard. Mohammad Ali Hussain, the counsel for the petitioner. All the respondents are there. Opinion at page 58. Passed by so and so in case number so and so, reference number so and so, dated so and so. They were declaring the petitioner to be a foreigner post 25 to 1971 stream. Next, by the land counsel for the petitioner has referred to annexure 16 and 17 to the writ petition to project that the petitioner had no knowledge of the impugned opinion, and therefore, on coming to know about the opinion, the petitioner had moved the learned member, Foreigners Tribunal number 7th, Tejpur at Balipara and by filing a application for condonation of delay and a review petition, modification of the impugned opinion was prayed for. However, the said application was not, the said two applications were not entertained, and therefore the petitioner had submitted a representation to the District Commissioner, Sonitpur, Tejpur, on 10/7/2025, and he had also submitted two separate representations dated 11/7/2025 before the Secretary to the Government of Assam from Home and Political Affairs Department and to the Registrar General of this court. Which was sent by registered post with AD. Next para. Insofar as the application for condonation of delay and the review petition is concerned, we take note of the fact that the affidavit appended to the said applications do not contain proper verification with regard to the statements made in the said two applications. And therefore, and I have full stop, moreover, comma, the notary public, comma, in a casual and cavalier manner has attested the affidavit sworn before it without ensuring that the gap left in respect of the paragraphs be filled up so that the applications can be, the statements made in the application are duly verified. Full stop. Therefore, having found the said applications defective, comma, the said applications are treated as non-est and therefore non-entertaining of those two applications. Cannot give any advantage to the petitioner. Next para. In respect of the impugn opinion, comma, issue notice returnable on, give a date after 4 weeks, returnable on so and so. Extra copies within 2 days. That the relevant records be called for on the concerned tribunal by the following email address. Next para, the prayer for bail shall be considered on receipt of the tribunal's records. Next para, in the meantime, if the petitioner, namely Hasina
Begum.
Hasina Begum, Hasina, Hasina Begum, alias Hasina Khatun, Khatun, is apprehended, comma, she shall not be deported out of the country without order of the court. Next para. Petitioner shall produce shall cause production of a certified copy of the order before the Superintendent of Police, border, Sonitpur, Tezpur, based on so and so.
Item 12 for motion.
Your lordship, can you letter will be passable for the time being?
Item 13.
Opinion is at page number 17. Operative part is at page number 25. Order dated 4/4/22. Whereby the
We'll-
petitioner was
We
declared
put a question as to maintainability of the petition, which we'll argue on the next date. We are issuing notice and calling for the records. Heard Mr.
MR Sodhi.
M.R. Sodial, Planet Counsel for the petitioner. All the respondents are there. Opinion at page 17, dated 4/4/2022, passed by so and so. In case number so and so, FT case number so and so. Thereby declaring the petitioner to be a foreigner, post 25/3/1971 stream. Next, in view of the inordinate delay in batches, comma, keeping the issue of maintainability open, I show notice returnable on same date, on so and so. Extra copies within 2 days. Call for the relevant records to the following email address of the Learned Tribunal. Next for the prayer for bail shall be considered on receipt of the tribunal's reports.
Development.
Item 14.
Just one. Yes. Which page?
Page 25, it's an ex parte opinion. The order is of date 27/5, but the copy was received by me at page 24, only on 15/10/24. At page 24. Deal may be continued.
Okay. Heard. Mr. D.K. Agarwala, counsel for the petitioner. All the respondents are represented. Opinion at page 25, dated 27/5/2024, passed by so and so in case number so and so, IMDT case number so and so, thereby declaring the petitioner as party opinion. They were declaring the petitioner to be a foreigner. Or post 25/3/1971 stream. Notice. Extra copies within notice returnable on same date, 18. Extra copies within 2 days, call for the records. The prayer for bail shall be considered on receipt of records. Next, in the meanwhile, if the petitioner, namely Samartha Mesa, SHAMARTA, Mesa, NESSA, is apprehended, or she shall not be deported out of the country without order of the court. Next, the petition shall cause production of the certified copy of the order before the Superintendent of Police, Border, Borpeta, to bring the order to the notice of the said authority.
It is two things. It's A, when I received the certified copy on 10/24. And
No, that's okay, but
October.
we'll have to examine whether because the
I received the
tribunal
notice.
received that you had served the notice.
Yes, well, I received the notice, that's all correct. I'm not denying that. And I'm 62 years old in lady. So because.
It's okay, but once it's crossed 1 year, we'll examine the records and then consider a prayer for bail.
So one thing, there's a tricky situation. Your lordship has asked me to go and submit the copy certified.
Cost production. You have said you should cause production of the certified copy before the said authority.
But that's.
You want to go and give it yourself?
No,
Okay.
much obliged.
Item 15.
Maybe lordship. Lordship, page 133, lordship, is the input order.
Page number?
133. The new order, lordship, order with 7/5/2025.
133.
Yes, wonderful.
Okay. Heard Mr. S. Hawk. Learned counsel for the petitioner. Opening is it? Opening is it? Pardon me.
Lordship,
Oh, it will be the Deputy Commissioner. Deputy Commissioner, no,
5 Lordship.
5 is Superintendent of Police Border, Kamrup.
Rural. So he
Amin
has-
Gaon.
Please write Amin Gaon before that. Okay,
Huh?
so they have to write Amin Gaon Kamrup, then it becomes clear.
Oh, I understand.
Yes, Lordship.
Kamrup Amin Gaon.
Yes.
It will cause you. Don't forget this Amin Gaon.
Yes, Lord.
So this is hotline counsel of the petitioner. Opinion is at page 133. As by so and so. Case number so and so. Opinion dated 7/5/2025. Notice returned in 4 weeks. Call for the records. Extra cost in 2 days. Prayer for bail is opposed by the United Standing Counsel for the FT matters. Considering the projection, bail of 10 days time to take bail of rupees 5,000 to the satisfaction of Superintendent of Police, within bracket border, Kamrup Amin Gaon. List of polls of receipt of records.
Name correct, that will also by hand.
You have to file an IA and get it amended as per the High Court rules, notifications.
Time being item 12.
Let the imperial opinion personally find at least 72 measure,
Page,
72 measure,
page
72.
72.
And it was passed on 12/12/2022. measure.
Mr. S. Hawk, Learned Counsel for the petitioner. For the respondents of the opinion at page 72, dated 12/12/2022. Passed by so and so in police reference case number so and so, but thereby declaring the petitioner to be a foreigner post 25 1971 stream. Notice returned over on 18 September, 15 September 2025. Extra copies within 2 days. Call for the records to the following email address of the Rana Tribunal. The prayer for bail shall be considered on receipt of records. In the meanwhile, if the petitioner, namely Muhammad Abdul Salam, is apprehended, and shall not be deported out of the country without order of the court.
Right.
The petitioner shall cause production of the certified copy of the order before the Superintendent of Police Border, Morigaon, bring the order to the notice of the said authority.
Right.
Please transfer, sir.
Item 16.
May please, your lordship. Lordship would find the impugned order on page 92, annexure 17. 92, annexure 17. Lordship, the date of argument here was on 2019, 11/2019. Thereafter, after 1 year, the order was passed. Now, your lordship, there is an allegation against the advocate, your lordship, and a complaint has been filed before the bar council, your lordship. Your lordship, that's on page 98, 97, 98. Your lordship, though we have not made the advocate and party in this petition, your lordship, but the allegations are little serious, your lordship. That for the last 5 years, they are in contact, your lordship, but it has not been informed that an order has been passed against the petition. It is only after the pushbacks have taken place, this order has been handed over to them. It was applied on 4/6/25 and handed over to the petitioners on 23/6/25.
This complaint doesn't take us anywhere. It really doesn't take us anywhere. That allegation. You know the reason why? Because subject to correction, I have read this long back, I may have forgotten. But under the advocate's ethics, it is not the requirement of a council to give certified copies. Unfortunately, it is not there.
Yes, lordship, the allegation here is that she was not.
You say that the allegation is that you are doubting the integrity.
Lord.
You know the meaning of integrity? Integrity in context of a lawyer would be that he is hand in glove with the respondent. Here the respondent is the state. And so therefore it can't be accepted that a lawyer in a foreigners tribunal cases would be hand in gloves with the state. Out of question. Then what would be the meaning of integrity? What sort of integrity you want from a lawyer? This is fun to know because at an opportune moment we may pass orders. This is how the advocates should have their integrity. May not be in this case, but in an opportunity, we always get an opportunity. Tell us, what do you expect of a lawyer? The advocate ethics, I don't know which book may have it, but there's one book of late senior counsel B.K. Goswami, a bluish book, which has the code of ethics recorded. I read it long back, but I don't remember it having anything that is, it's a duty of a council to have certified copies issued. And I'll tell you something very strange. We talk to many people, in fact, those who are connected with the affairs of this court. You know, what is one of the major grievances of the lawyers, advocates, clerk, which are working in this court and in the establishment of the Chief Judicial Magistrates Court? You're aware of it? No. They don't get engagement for obtaining certified copies. Most of the advocates, clerks say that the young lawyers have started applying for certified copies, they are getting it, and they are becoming unemployed. If you doubt my statement, at 1:15, we'll go to the advocates clerk's room and we'll make you talk to this advocates clerk. They are lamenting because the lawyers are now taking up the issue of getting certified copies.
Yes, Your
It is
Lordship.
one of the major grievances. So if this lawyer has not procured a certified copy, we can't say take an offense. So therefore, your complaint doesn't take us anywhere.
Your Lordship, the allegation here is not about only the certified
Oh,
copy.
4 years, you don't go. We are putting a question on maintainability. We'll have to answer it. We'll take it up. Not today, but we'll take it up.
Sure.
Heard Mohammed Ayusun, I'm counsel for the petitioner. Anybody, we can plan Mr. Day, Mr. Day? Am I wrong in saying that the advocates clerk have grievance of not getting adequate work? No, because I don't know, I've been hearing of it. I just want to hear it from you whether you have also heard about grievance of the advocates clerk of not getting adequate work because of certified copies.
Sometimes it happens,
Huh?
but not always, my.
No, not always, but no, it has to be always. Has to be always. Otherwise, this complaint would not have come. You're not aware of. Okay. I have sent the counsel of the petitioner. Opinion dated 24/12/2020. Page 92. Passed by so-and-so in case number so-and-so, corresponding to FT case number so-and-so, they were declaring the petitioner to be a foreigner of post 25/3/1971 stream. Next, review of the inordinate delay and batches in filing of this. In accepting the impugned opinion, keeping the issue of maintainability open, notice returnable on so-and-so, same 59. Extra copies in 2 days, or for the attainment records from the concerned tribunal at the following email address. Next, prayer for bail shall be considered on receipt of reports. Next, the event the petitioner is taken into custody, grant the petitioner now liberty to file an interlocutory application.
Item 17.
Item 17. 17, no?
It should be open,
Amendment
Jharkhand,
dated-
Lordship.
Respondent 3 needs a correction, Lordship. It will be DCP Kamrup Metro, Lordship.
Incorrect nomenclature of respondent number 3. All right. The Learned counsel for the petitioner is granted liberty to is directed to submit a freshly typed out cost title with correct nomenclature of respondent number 3 and hand it over to the AOJ FT section within 2 days. That the matter be listed in the motion column thereafter.
It's a good metro, na?
Item 18,
May page. Opinion at page number 57.
Opinion.
Dated number 6/7/23.
Mr. R. Ali, learned counsel for the petitioner.
HM.
H.A. Ahmed, I'm sorry, H.A. Ahmed, learned counsel for the petitioner. All the respondents are there. Opinion at page 57, dated 6/7/2023. Asked by so-and-so in case number so-and-so, police reference number so-and-so. Declaring the petitioner to be a foreigner of post 25/3/19 Sullivan Stream. Notice written over around 59. Call for the extra copies included, call for the records. Period for bail shall be considered on receipt of records. Next, in the meanwhile, if the petitioner, namely Renuma, RENUMA, Renuma Begum is apprehended, or she shall not be deported out of the country without order of the court. Next, the petitioner shall cause production of a certified copy of the order before the Superintendent of Police, Border, Borpeta. Then the order,
Baksar.
what's the bit?
Now it is Baksar.
Now it is Baksa.
Baksa.
Okay,
That match the party man.
okay. Superintendent of Police, Baksa. Okay.
Hello.
item 19,
May I please have a seat? Exposure of it is 26 of it. Dated 18/1/2020. Yes, yes.
21.
Yes, okay.
You have to satisfy on the ratio of maintainability on the next date.
Can you see between since
So we'll get it on that day. Let us call for the records. Heard Mr. P. Baran and counsel for the petitioner.
Go.
America. The filing section,
Yes, Lord.
this, it will, it's very good. You have to go to the, Mr. Vora, you have to go to the filing section. This is not signed by advocate or the client. It must go back. It is observed that the filing page containing the description of the advocates containing declaration about the mobile numbers. It's not been signed by the learned counsel for the petitioner to stop it. Accordingly, the matter is sent back to the AUJ filing section to do the needful. So thereafter, the matter will be listed again in the motion column. We're sending it back today. Pardon me? It will go to the filing section, it will sign it, it will come again. If you have passed an order, it will come in motion column immediately. Let me put here. Put here.
Hello.
You go to the filing section, it will come.
Item 20.
May please, your lordship. My lord, here the improved order is at
Opinions page.
page 82. Annexure 80.
Mr. A.R. Sigdal and counsel for the petitioner. Opinion at page 82, dated 31/7/2025, asked by so-and-so in case of so-and-so, police reference number so-and-so. They were declaring the petitioner to be a foreigner of post 25 to 1971 stream. Notice returnable within 4 weeks. Extra copies in 2 days, call for the records. Therefore, bill is opposed by the analyst and the prosecutor.
My lord,
Considering
he
the
is taken custody on the date of delivery of judgment. Now, we have filed a separate, I also made a statement in paragraph 15.
okay. I,
IA 2628.
oh, okay. Is that the public records?
Para four, para three.
by following email address of the Learned Tribunal. List on. So and so. Inflow application. Ms. Verma,
Yes, sir.
here it's a opinion of July.
July,
Will grant bail.
she's in custody law.
Has to be because once it is a very few days.
My lord, once a government has issued the instruction, my lord, not to, only to give the opinion. Tribunal should take any active part to give the person. on
We are not following you. What do you want to say? No, because you see, after that opinion, we really can't find any fault. If it's apprehended, we can't say anything.
Right.
After that, in the IA.
Lordship. Lordship asked me something.
No. In this interlocutory application, we are allowing it, prayer for bail, we are allowing it. Heard. So here, Siddhar will consider the petitioner, the respondents are there. Next part. By filing this interlocutory application, comma, the applicant who has been declared to be a foreigner post 25/3/1971 stream wide opinion dated so and so, passed by so and so, so and so. Yes. Stated that after delivery of the opinion on 31/7/2025, comma, the applicant was taken into custody and sent to the transit camp at Matia Gwalpara. And accordingly, is prayed for bail. Next para, the affidavit appended to this interlocutory application is by who is he?
Three I have stated. Yes. Affidavit, my lord, is son-in-law, my lord. Son-in-law, Baharul Islam.
Is sworn by Baharul Islam, was declared to be the son-in-law of the petitioner, applicant. Next para. The prayer for bail is opposed by the Learned Standing Council for the FT matters on the ground that as the applicant has been held to be a foreigner post 25 in 1971 stream. She cannot be given the liberty to to remain outside. As the applicant has to be deported out of the country. Next para, be that as it may, as the petitioner has been declared to be a foreigner by the opinion dated 21/7/2000 Oh, you are in your petition, there's a typing error. You are, time and again, we are, we are only looking at that. Page 4,
Page 4 of the, my lord, IA.
IA. Here you have made 10 years back. 2015.
No. Let me see the order. Import order 21, yes, my lord.
Some bad habit here and there. Wherever the mistakes are, the eye goes there only. There has been the opinion passed on 21/7/2025.
15 is there. 20,
And the said opinion has been assailed in the, by filing the connected WPC 4580/2025. Court is inclined to grant bail to the petitioner, namely so and so. Those 3 conditions. And after, but there will be some delay in your release because of this 15th. You will be released by 19th of August.
my,
Released by 19th of August. Because this is law and order duty, they will be engaged.
My-
The SP will not be, you cannot
my
leave
lord,
the,
yes,
that place.
deep level legislators.
I think so, how this goes on. We'll take a short break and come back.
Item 21.
Opinion page 25, my lord. And relevant portion
Opinion, where is the page, which page?
25,
25.
25.
Okay. Heard Mr. S. Mitra and counsel for the petition. All the respondents are there. Page 25. Opinion dated 29/4/2025. Passed by so and so in FT case number so and so, reference case number so and so. They were declaring the petitioner to be a foreigner of post 25/3/1971. Notice returned within 4 weeks, extra copies within 2 days, call for the records. Prayer for bail is opposed by the standing counsel for the FT matters. Considering the projection, 10 days time to take bail of rupees 5,000. To the satisfaction of Superintendent of Police Border,
Walpara.
Gwalpara. List up to 4 weeks on the city records.
Supply item 42 for motion.
Great, please, the lordship.
Yes.
Lordship will find the impugn order on page 98. The typed copy is on page 90, the lordship. Okay.
98. Mohammed I. Hussain and counsel for the petitioner. All the respondents are present. Opinion dated at page 98, 2/4/2025. Passed by so and so in FT case number so and so, reference number so and so. They were declaring the petitioner to be a foreigner of post 25/1971 stream. Same notice. Returning before weeks, Extra copies within 2 days, call for the records. Bail of rupees 5,000 to the satisfaction of Superintendent of Police Border,
So, Your Lordship, it's only two, Your Lordship.
Sonitpur, Tekpur. List of police on the set of records.
Supply item 43 for motion.
Lordship, in this case, Your Lordship, she has been apprehended, Your Lordship. And thereafter, Your Lordship, we approached this honorable court, Your Lordship, this honorable court gave us the permission to meet her and obtain her wakalatnama. Thereafter, I'm present for this honorable court, Your Lordship. Here, the impugned order is on page 52, Your Lordship, annexure 14,
52
Lordship,
of 2022.
2020. Your Lordship, this is a case, Your Lordship, where the petitioner's name has been enlisted with her parents in her parental house itself, Your Lordship. In the year
We'll call for the records, then we'll consider. In the meantime, it will not be deported out of the country.
And Your Lordship, may I be allowed to meet my family at least once in a month, Your Lordship?
You make a prayer, we'll allow, will not pass general order.
Lordship.
This time we are permitting you, but you filed an application because we're not giving a general order. Heard Mohammed Ayusil and counsel of the petitioner. All the respondents are there. Page 52, opinion dated 10/8/2022. Passed by so-and-so in case number so-and-so, corresponding to SP inquiry number so-and-so. They were declaring the petitioner to be a foreigner post 25 to 1971. Next, the counsel for the petitioner has submitted that pursuant to the said opinion, the petitioner has been taken into custody on 26/5/2025 and is presently lodged at the holding area at Matia, Goalpara. Notice returnable on 59. Extra copies in 2 days, call for the records. The prayer for bail shall be considered on receipt of records. Next. In the meanwhile, it is provided that the petitioner, namely so-and-so, alias so-and-so, who is currently being lodged at the holding center at Matia, Goalpara, shall not be deported out of the country without order of the court. Next, petitioner, the family members of the petitioner, it's permitted to produce a certified copy of the order before the in charge of the holding area at 7th AB Battalion, Saraikola, Matia, Goalpara. Just one such production of certified copy. The in charge of the said holding area at Matia, Goalpara shall also permit the petitioner, the husband of the petitioner, namely CHAYFATADDIN, Ahmed. I'm repeating the spelling, CHAYFATADDIN, Safaddin Ahmed, page 59. And one family member to meet the detained foreign national, namely Rabia Begum, alias Rubia Begum. Next, list on 59/2025.
Upgraded item 29 for admission.
Yes, you file an affidavit. Hmm?
Doctor, we wait for a week's time to file the affidavit. No, he lost the phone.
I'm not getting it. Please repeat again.
Instructions are there, but we haven't filed the affidavit.
Okay, just.
I have just a copy of it, right?
Okay,
Lordship, he has already been released on 28th.
no, we got it. Let's file an affidavit.
Lordship may close this.
No, no, you file an affidavit because,
Lordship
yes,
says the filing it.
file an affidavit. Because you,
It's a case of mistaken identity.
yes, it's okay, but let that be affidavit be filed. That we took note of on, by order dated 21/7/2025. It was, I see. Both sides are represented. The 11th Standing Council for the FT matters placed for further, how much time?
2 weeks, Lordship.
Further 2 weeks time to file affidavit in the matter. List on, give a date after 2 weeks.
(27/8). Item 38, upgraded item for orders.
May I please your lordship.
Yes, in 38.
This matter was heard by his lordship, Amar Pata matter. And it was fixed for order on 10/1/2024 matter. Actually, these petitioners, my lord, they were arrested on 4/11/2023, my lord. And presently they are in the detention camp, my lord.
But you'll have to address us on the issue of maintainability because there's a huge delay.
Yes, ma'am.
Which page is that opinion?
Our opinion is that,
Is it
my
at
lord,
page 105?
105.
Yes.
My lord, here, my lord, all the petitioners, my lord, belongs to one family, my lord. And, the reference against the petitioner number 225, there is no reference, my lord. Even, my lord, no inquiry was made.
We are in tension, Matya.
Rama, send him the house. He's just not there.
Lordship,
There is something in the inquiry which will perhaps make every one of us proud. You see, what I was surprised is, you know the form, down below, form,
Yes, Lordship.
this, no, the form, 4-page form. Yes, that one, huh. Now, left side, there's entries of people who have come with age.
Yes, Lordship.
In the left side,
Yes, Lordship.
there's entry of people with age. You've seen that? Age is 32 years, 8 years, 6 years,
4 years.
4 years and 2 years. In the left page, no, they're the same, left page.
Yes, Lordship.
No, the left side page of the
This
same,
side,
same.
This side, yeah.
Yes. There you see the date of coming, 77. So after entering into India, they've not aged. 2 years, child remained 2 years. This should make everybody proud.
This side.
But there's no reference.
There's no reference and matter after being like then detention since 23 Lordship, which is the IA Lordship. I just went through the IA copy of the IA.
No, for the respondent number 1, it will still be the issue of explaining us the delay in latches.
Yes.
That has to be heard. Now, on the delay in latches, what do you say, Mr.
I
Raka?
have stated in para, my lord. Para 17, 18, my lord.
17, 18.
Yes, please.
The petition.
May I read, my lord? In my petition.
Doesn't matter, no point reading it.
My lord, I fairly submit, my lord, there is a lapsus. my lord.
Because if that is so, then for number 1,
See the para 6 of the opinion, my lord. Kindly have a look at para 6, my lord.
That I feel okay.
Para 6 of the opinion, my lord. May I read, my lord?
yes, you did not file any, what you call, it was not proved.
Yes, my lord, my lord, no opportunity, reasonable opportunity was given, my lord.
Reasonable
Yes,
opportunity.
my lord.
Kindly read the foreigners' orders,
My lord,
1964, what would be the reasonable opportunities given there?
my lord, I fairly submit, but there is a lapsus, my lord.
No, but still,
Nothing to
you
place.
don't have a ground.
Even, my lord, these are, my lord, economically backward.
We can't entertain revision with,
Just, my lord, except, my lord,
After
there is a communication gap between the advocate and my lord, the businessman. And on the day of my lord passing necessary order, this impugned order has been passed now. Matter was fixed for necessary order. And on the very same day, my lord, the impugned opinion was passed now. Para 6 may be convinced me.
maybe there are people like this bench. We hear the matters at motion stage, we hear matters at admission stage, hear matters at order stage, hear matters at the hearing stage. So if you don't cooperate with the tribunal,
I fairly submit, my lord, there is a lapsus on the part of the patient, there is a great lapsus.
and the explanation given is not acceptable. Because if this is accepted, then we'll have to accept everything You were diagnosed of liver disease, you were diagnosed of digestive disorder. Every 9 out of 10, maybe even in this courtroom would have some digestive disorder.
Otherwise, petitioner has a valid document, my lord. And thus, my lord, a single opportunity will be given, my lord. He has a valid document, my lord. I have placed before lordship, my lord, all the document, my lord. The document before 1991 or 71, my lord, and the document related to my lord after 1971. All documents are there, my lord.
Yes. Lordship, just wanted to point out, page 18 of the IA, Lordship. Page 18 of the IA, which my friend has filed, Lordship. Paragraph 6 of the opinion, Lordship. Why the final order was passed on the day of passing of necessary order, Lordship? In the middle of the paragraph, Lordship will see.
Just a moment.
Yes, Lordship. Yes, Lordship. It can be legal.
This is the last order.
Last order.
24/4.
Yeah, I forgot. Last order, yes.
অপরপক্ষে 480/17 নং দর্শকে নিযুক্ত অধিবক্তাৰ অধিবক্তাৰ বাবে সাক্ষী লবলৈ অসমৰ্থ বুলি জনাই সময় বিচাৰিছে। সদস্য মহোদয় মূল কাৰ্যালয়ৰ পৰা বাহিৰত আছে। ধাৰ্য 7/17
বিবিধ হুকুমৰ বাবে।
Yes, sir.
Correct.
হুকুমৰ বাবে।
So in English, roughly translated in English would be that the presiding officer is out and therefore lists the matter for passing appropriate orders. Correct?
Yes, sir.
Or necessary orders, whatever it be. Just look at the next page. Opinion has come. Where is the hearing? opinion has come on a date when the presiding officer was not there. Bench assistant writes the fixed for necessary orders. The opinion comes. It's not been notified for hearing.
Lordship, in the opinion of the state, if the Lordship has gone to the
Yes.
opinion, Lordship,
Yes,
page 18 of the IA Lordship. Paragraph 6,
correct.
9 lines from the top Lordship. The matter was fixed today, that is on 7/6/2017 for passing necessary order. But today on the 7/6/2017, the learned engaged counsel so and so has appeared and filed yet another petition being so and so, praying for time to adduce evidence by the OPs as the OP is suffering from fever and diarrhea. Hence, it is observed by this tribunal that the OPs have not started their trial for long 13 months. Since 3/5/2016 till today, that is 7/6/2017.
That's why we
today
showed you this order sheet.
Yes, Lordship.
You see, that is why we are showing you the order sheet.
Yes,
On
Lordship.
the last date, the presiding officer was not there. He did not put the matter for hearing. It's normal for a trial court bench assistant to write that since the presiding officer is absent, fix on so and so for necessary orders. That order is an administrative order because there cannot be a record without a date or without an order. So this is very usual. Unlike the High Court, when supposing I reach only item 20 in a list of 50, others get left over. And there's no record of what has happened, except for the cause list, we don't have anything. That doesn't happen in the trial court. It's not fixed for hearing.
It was not fixed, but he has explained it.
No,
in the
because you see
opinion,
what we say in our order. I am speaking in the bench, I am speaking for myself. What do I say? That the counsel is unrepresented. If the petitioner remains absent, adverse orders will follow. Or I say that it's fixed for ex parte hearing. Because in a trial court, it's absolutely necessary to say that this matter is listed for hearing. You go through the records, think over, we'll take it up at 2 o'clock, this matter. Just go through the records.
We don't have a copy for this petition.
Give a copy to him. Let her go through it. Take it up at 2 o'clock. Oh, 40.
Upgraded item 40 for orders.
Yes, legal lordship. My lord, here in this case, my lord, to file a review along with a confirmation petition, my lord. The defect was not of our notice, my lord. And when we pursued that matter is not coming in the list, then only to know that there is some defect. We have initially removed the defect, then again another mistake, my lord, the filing section has picked up, then we have also removed the defect. So, my lord, only our fault is that, my lord, when we pursued or not listing the matter, then we could know. We are not notified about the defects. So, that is, that fault is on our part, my lord. We have delayed the pursuit of office matter for not listing. Oh, opinion. Opinion तो अपना दोनों opinion तो दिया था तो clear was developed quickly. They must have the life and you will we get to hearing about formal capability. You interview. ठीक है ठीक है review to number 1 है convention file delay तो अपना से ये हिजत को कैंसिल डिलीट करा इनका नতুন फाइल को लिखते एक्चुअली तो देखते हैं डिलीट करा ये इंजीनियर फाइल तो बिल्कुल तो इंजीनियर विषय फाइल ऑब्जेक्ट रिलेशन नहीं होता in the beginning to bona fide proceeding for our districts one.
Your statement may not be totally correct. Because what we are aware, since long back, this practice was there. Once it is there in the defective list, a list is maintained for the defect. It's not that it goes unreported. In the filing section, there is a list of defective filings, which goes to the defective bench.
We have, we also admit our fault that we have delayed in pursuing the matter for listing. And when you pursue the matter, why not listing? Then only you could know that. There may be list matter in the office. That
Okay,
that may be our lapse on our part.
We'll
I
examine and
admit-
pass orders later
I
on.
admit, my lord,
We will examine and pass orders later on. We will call for the concerned person to understand how this section would function.
My, my,
There's a delay of 2000 days.
my lord, taking account from the original order.
That's okay.
But in the meantime, my lord, he was after judgment of the, my lord, in the writ petition, he was taken in custody, my lord. Then after 2 years came out, then file review in 2021. My lord, when the matter was come up in the hearing, my lord, then the formal debate was detected and we withdraw with the liberty to file a fresh one.
Okay.
That is the, my lord, fact.
Where is the order of withdrawal in the
My
review
lord,
petition?
I have
Is that
also annexed, my lord, in the IA as well as in the main review petition. Annexure A to the IA, my lord. My lord,
It's a
paragraph
page?
9
Page?
is, it start from 9, my lord. Para 9, my lord, is relevant to us.
But this would not help you. This will go against you. Because here paragraph 10, the review petition with the above observation, this review petition on withdrawal being infructuous stands dismissed.
My lord, I am praying, my lord, for looking to the paragraph 9, my lord. Leave to
9.
para 9, my lord. File without certificate of learned filing advocate, leave to that extent has been granted. But without granting any leave pertaining to the delay in filing the review petition against the order dated from past instance.
Okay. Okay. We may be 5 minutes late in assembling again post lunch.
Develop.
Item 38, fixed at 2 p.m.
Yes, you've seen the reports. You're proposing to interfere with that order. You're proposing to interfere with that order. There is no reference against 2 to 5 and then you never put off a hearing. We pass orders in the chambers. You have anything more to say? Uh, 3 months from the date of first appearance when you are fixing.
Healthcare may be
Perhaps-
sent to registry also.
Yes. Perhaps
Actually, I was placed the LCR also.
Hmm?
I placed the LCR also.
we'll ask the registry to send it back,
Yes,
or you will send
regist-
it back.
No,
We can
no,
give it to you.
through registry also.
Okay.
Yes.
Okay, the passport is in chambers. You may get it tomorrow. Tomorrow also in the second half, not in the first half.
All the all petitioners are behind the applicants.
We'll take into consideration that.
Highly organized.
Upgraded item 41 for orders.
May I please?
Yes,
My lord, first I draw your lordship attention, kindly see page two,
page 2.
the petitioner's names.
Yes,
Ashraf Ali, son of Janab Ali,
yes.
and Hafiza Begum, wife of Ashraf Ali. So, here, my lord, I have some interjection. Because Ashraf Ali will get the nationality from his father. And Hafiza Begum will get the nationality from her father. So both the husband and wife has been made together and the case has been deferred. So it is, I think, there should have been a separate reference. Because their documents should be totally different from each other.
Okay.
Then Lordship would kindly say, page 127,
Of the writ petition or review petition?
review petition. One 127,
Just a moment. Yes. Page,
There, Kitab Ali,
page number?
127. This Kitab Ali is the own brother of Ashraf Ali. And this Kitab Ali has been declared as Indian. And let's see page 131. Opinion, and considering the materials on record and findings above, I am of the opinion that the OP has successfully discharged his burden of proof with cogent, reliable, and admissible evidences. In the result, the reference is answered in the negative and in favor of the opposite with Kitab Ali, son of Janab Ali, of village Borbori under P.S. Dharampur, declaring him as citizen of India. So my own brother has been declared as Indian.
Yes.
And Lordship is aware about the case of Abdul Quddus, para 80 to para 28, that any order passed in favor of close relatives of the proceeding shall be definitely a positive effect on the proceedings case also. So, this Kitab Ali, who is my own brother, and those are on record. So, Ashraf Ali should be also declared as an Indian in view of the judgment rendered in the Abdul Quddus case, para 28. And another sister, my lord, another sister of this Ashraf Ali, that is Fatima Khatun, she has been also declared as not foreigner. That lordship may kindly see,
Which page was your opinion?
my lord.
In this review petition, which page was your opinion?
In the review petition, there are several opinions.
No, your opinion is where?
Landed single judge's order, page 29.
No, your opinion is where, in which page? Opinion against you is at which page?
Yes, that is in page 34. From 36, it is discussed. 51 NRC was there, 66 voter list was there, 70 was there, son of Janab Ali is also there. But the learned tribunal says, page 37, para 6. After summing up the materials on records and considering the submissions from both sides, I am of the view that OP, in the case of failed to prove that they were not foreigners or foreigners of any class or description as prescribed by the provisions of Section 9 of the Foreigners Act. Since the OP 1 and 2 are not citizens of India, 1 and 2, 1 means Ashraf Ali and 2 is his wife. Since 1 and 2 are not citizens of India, their children from OP number 3 to 8, though born in India, cannot be treated as citizens of India by birth. Hence, the OP in the case who illegally migrated after 25/371 are treated as foreigners under Section 2A of the Foreigners Act 1946. In the result, I declare all the OPs named above as foreigners. So, my lord, the reference itself is wrong because wife and husband cannot be club together referring their case because they will get citizenship from separate person. So it has created problem for us to prove that we are Indian citizens. Because my wife will get, but in this regard, I have also one judgment that this wife, that is Hafiza, her close relative has been also declared as Indian. That person may kindly see page 140.
Page 86 is the WS property.
Let me complete. You'll get your chance.
140.
140.
Yes. This Abdul Latif. Abdul Latif is the brother of petitioner number 2. Petitioner number 2, that is Hafiza Begum.
Bar of 2010. Feel careful because I cannot put.
And my lord, this Hafiza Begum's father's name is Abdul Sattar, village Borbori. And the present petitioners, her brother and other family members of her brother has been declared as Indians. Kindly see page 147. It is just for last portion, Lordship may kindly see. Last portion. Abdul Latif, OP number 1, and Sophia Khatun, deceased of OP number 2, were also legal voters for the year 1997 and 2005 for Jagiro, LLC from village Borburi, Excel Exhibit Jaw and Jaw, respectively. The Abu Tahir, OP number 3, Musammad Salima Khatun, OP number 4, are the children of OP number 1 and 2, and they were born at village Borburi as confirmed from exhibits NIA 1 and NIA 2. The birth certificates in their names which had also been confirmed, and that they were born on 5/2/1998, 6/7/2002 respectively. Exhibit 4 had confirmed that OP number 1, Mohammed Abdul Latif, is now a resident of village Borburi. At the argument of both sides, after a careful scrutiny of the discussion of the evidence of the witnesses, DWs, and on perusal of the documents exhibited in this case, and considering the same with care and caution, I am of the considered opinion that the surviving office in this case, namely Mohammed Abdul Latif, who is my brother, who is the brother of Hafiza Khatun, office number or son of Abdul Sattar. My father's name is Hafiza Khatun's father's name is also Abdul Sattar, and his children Mohammed Abu Tahir, OP number 3, Musammad Salima Khatun, OP number 4, have established and proved themselves as citizens of India by birth. In the result, I hold and deem all the surviving office named above, presently residing at village Borburi under P.S. Dharamtul, in their reference as citizens of India by birth, under the provisions of Section 3 of the Indian Citizenship Act 1955, as amended in 2005. Since the OP number 2, Sophia Khatun, expired, so this reference case is dismissed against her. The reference thus stands disposed of on contest afresh in favor of the surviving office. In the result, the prosecution case fails. So, my lord, my wife's own brother and brother's family members have been declared as Indian by the learned tribunal. And Ashraf Ali's own brother and sister, that is Kitab Ali and Fatima Khatun, they have been also declared as Indian. And over and above, this person was in custody for more than 2 years. Lordship may kindly see, I have filed an IA. So that Lordship may kindly see page 28 of the IA filed in this case. IA page 28.
Just a moment.
Now, Lordship may kindly see page 28 of IA, that is number 2237.
Yes.
25. In pursuance of the order passed by Honorable Supreme Court of India, dated 13/4/2020, right, so motor WBC number so and so, an order of the Honorable Guwahati High Court, Bhait WBC so motor number so and so, dated so and so, conveyed by the Superintendent of Police B, Assam, Guwahati Bhait number so and so, dated so and so, and WBC number so and so, dated so and so, the detainee declared foreign national Muhammad Ashraf Ali, son of late Janab Ali, village Borburi, P.S. Dharamtul, District Morigaon, Assam, who has been staying for more than 2 years in detention center is released with a direction to appear before the officer in charge of Dharamtul PS every week with effect from 1/6/21 regularly until further order. Now he is allowed to go on bail of rupees 5,000 only of one local surety of the like amount to the satisfaction of the honorable court. So, my lord, from all points of view, first thing, as per Abdul Qudus's order, para 28, when the close relatives have been declared as Indian, then, my lord, he should be also treated as Indian because they are the offspring of the same father. Secondly, not only one, but one brother and one sister have been declared as Indians. And so far, petition number 2, Hafiza, daughter of Abdul Sattar, and her own brother Amiruddin, he was also declared as Indian. So there is some complexity. In this case, there is complexity is evident on record because husband and wife cannot be sent together because they would depend on various different documents altogether. So I know knowingly or unknowingly, the prosecution has given us unnecessary troubles in proving our case. And I remember there is judgment of our High Court that same family members may have some better claim of citizenship. Suppose my sons may have better documents. They have birth certificates or school going certificates, etc., which I may not have. So in such a situation, so many persons clubbing together creates some problem. And secondly, husband and wife is totally uncalled for. So intentionally perhaps they have done this or wrongly. Whatever may be the fact, but the benefit I would get. And fourthly, my lord, I was in detention camp for more than 2 years. So in view of the order of the Honorable Supreme Court, as well as our High Court, the other day I have submitted, Lordship is aware about that. So I am now on bail. And I am appearing every week before the police station. So, my lord, order should kindly be reviewed. Considering, of course, my learned friend has said, WS, these things could not be elaborately discussed because these are the offsprings after declaring us as foreigners. So, that we have brought in the review petition, subsequent development. In this regard, our High Court has said categorically many things, my lord. Can we say that is 2005, 4 SCC 741, para 88, 89, 90. Board of Control for Cricket in India and another
2005?
2005, 4 SCC 741, para 88, 89, 90. Board of Control for Cricket in India and another versus Netaji Cricket Club and others. Now, Lordship may kindly say 88 what is saying by the Honorable Apex Court.
You don't have to read it because this is, we have heard it
Yes.
and read it many times.
Several times it has been discussed, my lord. Subsequent developments are also has to be taken important discovery. This is important discovery. Nowadays, declaring a person as an Indian after referring the matter, it is extremely difficult task because of many reasons. Names are differences, ages are different. These are rustic and illiterate people. So even then, they have got better orders. So my humble prayer is this, the review petition may kindly be allowed, and we all the persons who are the petitioners in this review petition may be declared as Indian citizen on the basis of the subsequent developments. Now, my learned friend may say, many things. But Honorable Supreme Court has clearly said, who are awaiting for deportation. So that thing is also here. Till now, if your lordship declares me as Indian, that would go. So my humble prayer is this, my lord, review petition it is a very good review petition, in my humble opinion. So this should be allowed, and we should be declared as Indians, and no further detention, because I was already in detention. That is my humble prayer,
I'll just ask you one question.
my lord.
It is not your case that there is any error in the order. You are merely asking for a review on the basis of subsequent development alone.
Subsequent developments and NRC, my own person's name had been also NRC. Now lordship is aware that NRC has become the finality. Now NRC
Well,
also,
I don't have the notification. You have the notification of finality?
my lord.
You have the notification of final publication of NRC? Because I don't have. Please give it to
There
me.
is the order of the Honorable Apex Court. I
we
think
don't know.
lordship
You'll have
may
to
take
show
the
it to us.
judicial notice, my lord.
No, you'll have to show it to us. If you say so, please show it to us.
My
You can
lord,
give
the
it by tomorrow
Honorable
morning.
Apex Court said the order of the Honorable Supreme Court cannot be forsaken by any pretext. Now government should
No.
issue notification.
Mr. Mahmood, it will not take you anywhere. Because if we have asked for a copy of the order, you'll have to give it.
Copy of the order regarding
Whatever you want to show, either notification or order of the Supreme Court.
finality, yes.
With
that
the
also
NRC
may-
is at the finality. Please,
Yes, well, that's,
tomorrow morning at 10:30, you can give before 10:30.
yes, well, that I may provide, but today I would not.
Tomorrow
be-
morning, we give a timing till 10, before 10:30 tomorrow.
Tomorrow. Let it be day after tomorrow, my lord.
No. You see, we have some handicaps. I have so many CAVs that I can't keep on piling up CAVs, one after the other.
Now your lordship has been
Every day-
versed in this
Every day, 2 or 3.
subjects.
No.
So
Mr.
time would
Mahmood,
be not necessary.
every day, 2 or 3 orders we reserve for passing in the chambers. 1 or 2 matters are being reserved for judgment.
Okay, my lord, let it be at 2 p.m. tomorrow at 2 p.m.
Okay.
because so many cases are there, so that is also has to be done. So
No, we have more matters in my list
Definitely.
than
That's
cases
not-
you have in your list.
heavily burdened, I understand that. But here's the question of my life and death, my lord.
Okay. Yes.
My lord, the review in the my lord, grounds of review. The lordship may kindly see page 14 is at 14. From page 14, it is grounds of review. Yep. The grounds of review are there. My lord, before going to that, my lord, your lordship will appreciate, my lord, this writ petition was dismissed in 2010. 2013. Then writ appeal was filed. Writ appeal was dismissed on my lord. The IA is there. In 2017. Then the review is filed in in 2023, my lord, with some grounds. The grounds before ours, before this honorable court is, my lord, number 1. It is the contention of the petitioner that the numbers of orders of this honorable court as well as honorable Supreme Court, that due to discrepancies in the name and address, persons should not be declared as foreigner. So this is definitely a matter of, my lord, appeal. In a review court, my lord, this cannot be reviewed because it is not error apparent on the face of the record. nor it is a new my lord, discovery which could not be brought before the court, this honorable court, despite of due diligence. Secondly, my lord, the grounds of review is a public, they disbelieve the public documents, which was argued in the writ petition, writ appeal, even in the tribunal. These things were, my lord, argued, and on this ground, it cannot be reopened because the writ petition cannot be argued in the, my lord, review, nor the writ appeal. It is not the review jurisdiction where this has to be agitated again and again, my lord. Then, my lord, the shifting of residence of the persons do not become foreigners, and yes, this is also argued in the writ petition, my lord. This is not the case that these were not argued. These were originally in the, my lord, tribunal's opinion. Then it is in the writ petition, then writ appeal. Then fourth ground is, my lord, the legal evidence of the witnesses were not believed by the learned courts, which has constituted serious prejudice to the petitioner. This is a matter of, my lord, argument in the writ petition. This were argued. Further, there are ample instances where the honorable court has ordered to accept fresh documents and additional evidence which are vital for the determination of citizens, which is most valuable right in the individual. He has referred to 2012 HSCC judgment matter, but this is settled position of law in the matter certiorari jurisdiction. No due documents can be accepted. That is, my lord, settled. And
You are arguing without, you are making submissions without knowing what the judgment is. This is Mohammed Ibrahimuddin,
yes,
and this deals with Order 41 Rule 27 at the appellate stage.
yes, they are in the appellate stage, my lord, it can be accepted. My lord, my submission is in the certiorari jurisdiction, it cannot be accepted. That is settled position. Appellate stage, yes, definitely it can be accepted by this honorable court, my lord, as per CPC. Then,
You see, without knowing the judgment, you will not be able to
Yes,
follow
yes.
what I am saying.
yes, my
In
lord.
in Ibrahimuddin, the
Yes.
law laid down is to the effect that in the trial court, effort should have been taken to need additional evidence. And if that is refused, that in the appellate stage, it can be
Accept.
accepted. That is the ratio in Ibrahimuddin, not otherwise.
That is,
So here, Mr. Mahmood will fail.
Judgment matter.
Here, Mr. Mahmood will fail because of the fact there is nothing on record to show that this was agitated and was refused.
first of all, my lord, it is again my submission.
It's okay.
Yes.
It's okay. You take your submission.
Yes. First of all, as your lordship has pointed out already, in fact, I was not aware of that matter. Your lordship has rightly pointed out. It is a matter of CPC and it is pure civil matter. There, in the appellate stage, if it was not allowed in the, my lord, court below, definitely it would have been accepted. Probably that is the my lord, position of law in that case. But our cases, but in certiorari jurisdiction, this honorable court will not entertain any document because it is certiorari in nature. In certiorari, my lord, the court power is the supervisory power. It cannot be taken as appellate authority matter. So being not appellate authority, it cannot accept new documents. That is settled by numbers of judgment of this honorable court as well as my lord honorable apex court. Then, my lord, sixth, quoted there are many new development in the case of the petitioners, as petitioner number one's brother named Kitab Ali. His claim is that once Kitab Ali has been declared Indian and recorded in the NRC 1951 along with petitioner's father, and Kitab Ali, instead of correct name Kitab Ali, his name is also recorded as various voter lists of 1966 and others. In addition to this, his sister Fatima Begum has been declared an Indian citizen by the Learned Foreigners Tribunal, Morigaon. Over and above, his another sister, Kulsuma Bibi, has also been recorded final draft NRC 2019. This is the ground of my lord review now. But first of all, whether Kitab Ali was ever introduced by the petitioner, either in the jurisdiction or in the tribunal or in the writ appeal. If Kitab Ali was his brother or any case was pending against Kitab Ali, those are known to him. It is not that, my lord, these facts were fixed, this Kitabali's brother, this knowledge will come now only at the time of review jurisdiction. This knowledge is there from very, if Kitabali's brothers, this knowledge is there. Despite of that knowledge, he did not disclose this thing. My lord, secondly, whether Kitabali is his brother, which evidence shows that Kitabali is his brother? First of all, he has to show by cognizable evidence, reliable evidence that Kitabali is his brother. Where is that? And it is not their case that despite of due diligence, my lord, there was due diligence to bring out this fact that there is a brother called Kitabali and he is declared foreigner or any foreigner cases pending against them. It is not, those things are not disclosed. Those are taken now only to get some benefit. And review jurisdiction, my lord, it is clearly review jurisdiction, review it is said, my lord, review jurisdiction, that when review will be allowed. If new evidence is come, my lord, is there, but that could not, the evidence could not be produced before the tribunal, despite of due diligence, my lord. It is not a new evidence. This was known to them. There was no approach or no disclosure, no statement that despite of the due diligence, this could not be produced, this evidence could not be produced in the tribunal. Where is that statement? So in absence of those, on this ground, the review cannot be accepted. And with regard to NRC, I have argued in another case, this Honorable Court has dealt down and settled also that in the NRC 2019, which is the draft stage, which is not yet accepted by the Registrar General of India, and it is not yet published. So it is not yet a final document. It is settled and it is there in the judgment, settled by this Honorable Court. In another issue, is my learned senior friend is Abdul Quddus. Para 25 of the Abdul Quddus. What it is, it has said, my lord, it is in para 20, one thing, my learned senior friend is, my lord, pointing, only taking the one portion of the judgment. In another portion, it is saying, yes, definitely there can be a contradictory opinion between two brothers, because one brother may come prior to 1971. One brother may come after 1971. So in that case, those has to be different. Their opinion will be different. That is checked in para 28 itself. Para 28 itself. Yes, Abdul Quddus case, my lord, in 2019 6 SCC 604. In that case itself, para 20. So when there is contradictory, there may be contradictory opinion in two brothers also. So my point is that, my lord, to take benefit of para 20 also, they have to first bring into the record, and there must be, my lord, evidence to show that yes, his brother was there, and he is his brother, which was not pleaded in any place, anywhere in prior to this review petition, my lord. Yes, his brother was there, and his brother also, there is a case pending against his brother also, or his brother is already declared foreigner, Indian. Those things has to be pleaded. Those things were not pleaded, never pleaded in either in writ petition or in writ appeal. Even, my lord, the Kitabali, whom the petitioner is now relying, that he is his brother, Kitabali's case was pending since 2010. FT case is 819/2010. FT case number is 819 of 2010. This
So
reference, IMDT reference is started
Which page you are referring to?
page 127, madam.
Yes.
Here your lordship will find the case was referred in 2000 because IMDT case number 305/2000 dated 25/9/2000. This case, application was registered at 8110, and this case was disposed of on 28/2/2022. That means, my lord, after the passing of the, after the writ appeal is dismissed by the Honorable Court. They took a chance, my lord. There is no other record. Only the opinion is there, my lord. From the opinion, we cannot find, my lord, that Kitab Ali has some brother in the name of Ashraf Ali or what.
Okay.
So neither Kitab Ali nor Ashraf Ali has disclosed the brother's matter. The Kitab Ali has a brother in the name of Ashraf Ali. Ashraf Ali has a brother in the name of Kitab Ali, and there is a case pending. Or the brother Kitab Ali has disclosed that brother has been declared foreigner. Any case, anything, nothing has been disclosed with it. Now, when Kitab Ali has been declared Indian by this opinion, they want to take benefit of this opinion without disclosing it on list. So very purpose, my lord, the review jurisdiction on the very purpose, my lord, first point is that this review jurisdiction is not maintainable on the given grounds, my lord, given grounds, taken grounds by the petitioner. Only, my lord, the petitioner wants to rehear the entire petition so that it can be again reviewed, my lord, by rehearing the earlier petition, which is not permissible. In fact, the petitioner went to Supreme Court also. It was also dismissed there. So they could have taken all these, my lord, points in the Supreme Court, and definitely they could go for appeal. In the appellate jurisdiction, they could raise all these questions. It is not the matter of review, man. My lord, to that effect, always, this is 2013 8SCC, my lord. I'd like to rely this judgment. Kamalesh Barma case, my lord. 2013 8SCC 320.
2013 8 SCC
320, my lord.
paragraph.
My lord, 20 and 20.2. Where review has to be accepted, where review cannot be accepted. This has been summarized after.
What is the name of the parties?
Kamalesh Barma, my lord. Kamalesh, KAMADS is Kamalesh Barma versus Mayawati and others.
Oh, acha. Okay.
In this case, my lord, the earlier judgments of Honorable Apex Court has been discussed and summarized in para 20 and 20.2, my lord, where it can be accepted, where review cannot be. Then what I have submitted, my lord, Abdul Quddus. before that Abdul Quddus, my lord, this, your lordship may find this is. And in this judgment, criminal appeal number 2686 of 2025, my lord. Citation is 2025 0 Supreme. My lord, 2025 0 Supreme. SC 870.
What is this?
This is, my lord, inclusion of NRC name in the NRC.
An NRC, okay.
Yes,
SC 870.
my lord. 2025 0 Supreme. SC 870. Rafiqul Haq versus Union of India. In criminal appeal number is, my lord, 2686 of 2025. 2686 of 2025. There in para 27, after discussing all these things, my lord, Abdul Quddus was also considered here. Para 27, it is said, my lord. In view of the-
Paragraph?
Para 27, my lord. Abdul Quddus was considered here in this.
Yes.
In view of the decision of the court of the Abdul Quddus Supra, firstly, consequent to declaration of the tribunal, the appellant is a foreigner. The name of the appellant could not have been included in the draft NRC. That is one aspect. Secondly, even if he has been included, not the brother's, my lord, the petitioner's name, even though petitioner's name included in the NRC, it would not annul the declaration made by the tribunal. Here the claim is that brother's name have been declared, had been inserted in the NRC. Even though the petitioner name is included in the NRC, then also, madam, the tribunal's opinion will be not, madam, annual. Because in madam, Abdul Quddus, it is said, madam, once the tribunal declares foreigner, his name cannot be included in the NRC. It will, madam, there is an appellate authority in NRC, madam, which is also called Foreigners Tribunal. That tribunal will decide whether the names of the name of the person is correctly, madam, included or excluded in the NRC or not. That tribunal. In Sopananda Sunwal, it is in this Abdul Quddus, it is said no, it will apply res judicata. So once the person has been declared foreigner by the earlier Foreigners Tribunal, the NRC Foreigners Tribunal have no jurisdiction because it will apply as a res judicata. So the NRC, secondly, NRC being, madam, this tribunal being quasi-judicial authority, what decision is taken by the tribunal, that will be not affected by the, madam, executive function of executive, madam, exercise which is done under NRC. So it is said, even though his name is included, here they are claiming is that brother is included, so his declaration is illegal. Even his name also included also, then also it will not be treated as, madam, illegal. that also it would be not affected. Further, para 28 says, for the reasons explained above, the inclusion of the name of the applicant in the draft NRC would have no bearing on the order passed by the tribunal, affirmed by the High Court, declaring the applicant a foreigner. It is affirmed by the Honorable High Court as well as by the Supreme Court. And this Honorable Court in the review petition by the 184/2019, it is decided on 5/12/2024. It is, the review petition was dismissed, and there also the ground was that the NRC, in the NRC, the name was included. My lord, there it is stated.
Just pass it on.
There it is, my lord, said that unless the my lord Registrar General of India published the my lord NRC, it cannot be accepted as a my lord. Para 28 of the Abdul Qudus merit for the timing. Para 28 what it says, my lord. This has to be read as a whole because only one part of this of
That you have already submitted, we remember that. 28.
yes.
we remember it.
Para 28 method, it is only two line I'll read, method. In the highlights of the, there could be contradicting decision or opinions of the Foreigners Tribunal, even in cases of the family members. Alleviate contradiction can be avoided in family tree hearings are held as is now being undertaken. In absence of joint decision, conflict is possible as principle of res judicata would not apply to separate proceeding, even if against two closely related different persons, as each case has to be strictly decided on their facts and evidence on record. Each case has to be decided on evidence on record and on their own facts. It is not that one brother has been declared foreigner India, one has been claiming that, no, I should also be declared Indian. That is not matter. It has to be appreciated on the basis of record, each and every individual record, not on joining. Secondly, there is possibility that someone of the near family members may have migrated to India prior to midnight of 24th 1971 and therefore fell different category. It may be in different category. Then it is said, any such conflict, however, would not compel to take us different view in terms of the clear statutory provision. That is that no, this res judicata will not apply in Foreigners Tribunal, this under 1946 Act and the Foreigners Tribunal under the NRC. So that point is there. Then it is said, yes, in that case, review, appeal, these are definitely these reviews powers, power of review, power of appeal, this cannot be stopped by this by any authority. If the provision is there, that can be applied anytime. If the evidence is new, then definitely coming. But that has to be after due diligence. So that's my submission.
Well, that could reply only short answer, my lord. My lord, first thing, my lord, law points may be raised at any point of time, including even in Supreme Court also for the first time. Law point can be raised even for the first time in Supreme Court, because that is the law of the land. Second thing, in Rafiqul Islam case, that is, it is said that draft NRC. But nowadays, NRC is not draft, it is final. Thirdly, my lords, regarding additional evidence, my learned friend has said already additional evidence is there. Here it is there. It has the foundation of the judgment of the Honorable Apex Court 2012, 8 SCC 148 para 36. 2012, 8 SCC 148 para 36. So far regarding Kitab Ali's Indian citizenship, Kulsuma and Fatima, these are also our grounds. These are also our grounds. Now, what my learned friend has said, that, Lordship, I am reading 2005 for SCC, which I.
Mr. Mahmood, we
My-
ask you a question. Is your petition contain the parameters which are there in this 2012 8 SCC page, whatever you are saying? Is your present petition compliant to those parameters?
My lord, that there is additional affidavit is there.
Either answer can be either yes or no. There cannot be any other answer.
In my opinion, the additional affidavit is there that it is up to your lordship. But my submission.
No, but
first
you're still not answering yes or no. It can either be yes or it can be no. We don't expect a third answer.
To some extent applicable, my lord, because additional affidavit is accepted. That is not rejected. My lord, that is para 90, which I wanted to draw your lordship's attention. That is 2005 4 SCC 741. That's a mistake on the part of the court. Who should include a mistake in the nature of undertaking may also call.
You are accusing us of making a mistake. Where is that mistake? We
No,
asked you.
no, this is
when
only
you-
one of the reasons. I am reading
see-
the.
You see, Mr. Mahmood, please read only those facts which are relevant to us.
Yes, that one
show
para,
us-
single para I am reading.
Mr. Mahmood, we
I
take
am
an
not-
exception to it. We asked you a question that is your review petition only based on the subsequent development? You said yes.
No,
Or
here,
you can change your stand. You can say
other
that,
things are coming. my
no,
lord.
no, you can change your stand and say,
Kindly
that-
bear with me for a
No, no,
while
no.
only.
you made a statement. Now you recall that statement and say that, well, I am one who can take any ground. I don't go by my
No,
own
no,
words.
It is, I am taking the grounds which have been allowed by the Honorable Supreme Court. Here, my lord, lordship, first thing mistake, that is, so many reasons are here, but one reason, the word sufficient reason in order 47 rule 1 of the code are wide enough to include a misconception of fact or law
What
by
is
a
that?
court
You have
or
not
even
urged-
by an advocate.
You have argued for more than an hour.
By an advocate also.
You have argued for more than an hour. Did you lay down that foundation?
Here, because I am compelled, because he said that regarding Kitab
Mr.
Ali.
Mahmood, you are cutting out a sorry figure for yourself.
The 69, kindly see, my brother's name, who has been declared the Indian, his name is
Mr.
with
Mahmood,
me.
please remember, I do not use harsh words. I repeat it for the 100th time, more than 100 time I am repeating it. I came as a smiling man here. While I leave the court today, after 4:30, I want to go as a smiling pan. I don't want to use harsh words. You are compelling me to use words.
Learned people say that those brothers who have been declared are not that, but their names
Please.
are with me.
You did not lay down any foundation of that. In your reply, you are building up a new case.
No, it is for a list, where our names are together. With common father, that I think, so many, para 69 to 76. Their names are with me, common father. So that is only my submission. My learned friends that I have, they are not on picture, but in voter list, our names are together.
Very old saying. When I entered the courtroom for the first time, first thing I was told that better know the judge more than you know the law.
I have
That
nothing
was-
said excepting.
That was the first lesson I received. And I think it was a correct lesson. You see, you don't give a citation. Name of the citation, you gave only 2012 8 SCC and I gave you the name of the judgment. Still, you are making your submissions without reading that judgment. You perhaps have read only the head notes and you are making a statement.
No. It is para 90. I have the.
Please read that.
That's a mistake.
No,
Let us
not
not
this, not BCCI. 2012 8 SCC.
2012 8 SCC. 2012 I have not brought, but one judgment, my lord. 2012 I have not brought, but one judgment 2001 SCC 666 here. It is said that judicial review is the heart and soul of the constitution.
Then, Mr. Mahmood, we have been wasting our time hearing to you. Is this a judicial review we are exercising? You don't know in the basics of advocacy. You don't know the basics of the parameters of judicial review. We are wasting our time. That's all. A review petition is equated as a judicial review. Thank God, we have heard you. You don't have the elementary knowledge of
No.
judicial review.
Other things are there. Other things are also there. 47, what is the admit of 47? That is also discussed there. But he has lost it.
No, well, we are hearing it very, very good. Every day is a day for education. If review petition is a judicial review, thank God we have heard you.
That is one of the aspects. So
I
many
told you,
things
this
are
is the
there.
third time you are repeating. You are cutting out a sorry figure while making those submissions.
Because all things I have stated on the basis of review judgment. Judicial review, I am not saying alone. Those things are on review. What is the review? That is also there. If your lordship allow me, I will explain that.
Just one, we will pass orders. Only for that citation, we are waiting. We are waiting only for that citation. At 2 o'clock, you are giving it to us. We will pass orders in the chambers. We'll take a short break of 2 minutes and come back. There is another good lawyer behind you. He will tell you the principles of Ibrahimuddin if you have not read that. Mr. Roy Choudhury. Mr. Salia, you are waiting for which item? You are waiting for which item? We'll take your matter. We don't want you to sit down.
Item 30,
Item
32.
32. Upgrade that.
This case, we are also on the last occasion, since there are some delay in filing this writ. All for the original records from the court or from the tribunal. Records are here. And
Just wait. Council have left. Just for a moment. Just take your seat, the council is not there. Yes.
Upgraded item 32.
You are considering 2021 opinion.
Yes,
Yes. What is the explanation tendered, Mr. Shalia?
my first year lordship will see, we are going to give opinions, Milord. The notice.
No, first is the delay.
Yes,
Delay
There's
part, how you have
delay.
explained.
there is delay, but my submission will be, Milord, since it's a matter. Opinion, your lordship will find at page 69. They said that I could not prove the linkage with my father.
No, first of all, there's a issue of limitation. And we, by the last order of 25/6, we have kept the issue of limitation open. because-
That time my humble submission, since it is a matter of, it is a question of law, whether I am a citizen or not. And I am covered by the Article 5/6 of the Constitution of India, since it is a constitutional right and a fundamental right to be a citizen. That delay in my humble submission is not a bar for considering the fact that whether I am a citizen or not. My simple argument regarding the delay will be that, it's a constitutional remedy I am asking for. And if Supreme Court in very many cases have stated, if there is a legal right also, then delay may not be very crucial. And in, I think, 2006 or I forgot, since I am not acquainted with those facts, 11 years delay was condoned by the Supreme Court, in that matter.
Because in your petition, you have not given any explanation. You merely have stated that you engaged a lawyer, you paid fees and nothing happened.
That is true, Milord, that is true. Unfortunately, I don't give any, I have not alleged anything against him, only that he has avoided filing the case, and for that I am at this status now. Correct. And during that period, as was his practice here, Milord, for the unemployed persons, Milord, he went out of the state, Milord, for doing job, and he was away for a long time there outside. So he also could not pursue the matter that way. Only when he came back, after his arrest only, it came to light, Milord, that here on merit, Milord, I'll take your lordship to the notice. At page 19.
Yes.
English translation in page 17. It states, Milord, the allegation is that he illegally entered Assam without any valid documents after 25/3/71. So if this notice is such, Milord, I am to show as whether I have entered after 71 or I was there prior to that. And for that, Milord, I have given my WS, wherein I have given all the details, Milord, that then he has proved, Milord, to voters list of his father those your lordship will find at the next are C and D.
Yes.
Where my father's name appears, my lord, along with his wife. In the voters list of 1966 at page 25-26, my lord. Karam Ali. Karam Ali. Will to print books. Karam Ali mother concept na I to Karam actually. And Annexa D also, same lot of 70, voters list of 70 at page 27. Originally at page 28. Annexa D, lot. Karam Ali, son of PR, and Kulsan Nesak, wife. Then I have given my own voters list of 89 million. Which shows where it is in Annexure E. Petitioner Salam Karam. Again, subsequent also, same thing. And on top of this, Milan, the Gaumura has also given evidence. He was cost. So these being public documents, Milan, no further proof, as my understanding goes, Milan, is required to prove that I am son of Kalimuddin Salam Karam.
Which document you say is the public document?
This voter list, Milan, certified copies of the public document, Annexure C and D, and all subsequent documents and annexures. These are all public documents. And no further these are being certified copies, Milan original life, certified copies being produced. No further proof is necessary more under the Evidence Act. They have given evidence, Milan, and the Gaumura was also there. He was also crossed. Gaumura's evidence you will also find at page 55. Page 55, Milan, he was crossed by the respondents. No, prosecutors. Yes, she says, I know who's particular Alimuddin, son of Late Karam.
That the tribunal has rejected because of the age gap.
My lord.
This man, Gaumura,
Yes,
he's about 23 or 27 years old. And the proceeding was 55 years old. So he could not have known the birth or the shifting. Then he says somewhere in this cross-examination that he heard from reliable source.
no, regarding their safety, that they were in earlier at different village, and now they are in the present village. He is 51 village, Gaumura.
But he says he came to know from reliable source. Somewhere he has said that.
No, he says, I have heard from other villagers that he and his father belong to Kochumara,
He heard from
another
someone.
village. That another village he knew later. But that he's the Gaumura and they are the villager of that village that he knows below. I know the opposite party family son, all. He's Gaumura since 92. below.
There is some problem with this Gambra certificate at page 42. Look at
My
page
lord.
42. Look at page 42. In page 42, he gives a certificate, NB. প্রকাশ থাকে যে উপরোক্ত আলিমুদ্দিন আর দেউতা করম আলীর নামটো 1966 আর 1970 চনৰ ভোটাৰ তালিকাৰ ক্ৰমিক নম্বৰ so within সমষ্টিৰ উল্লেখ থকা দেখা যায়. He is certifying something which is not.
On the basis of documents, he said. উল্লেখ থকা দেখা যায়. Because he is a resident of the village presently, and on the basis of these documents, he has given this, because Param is the father.
Then the personal knowledge goes.
My lord.
Then the personal knowledge goes. He derives knowledge from the document and he presumes that he is.
No. Regard that he is a villager of that village, that is there. That is there.
I'm sorry, I'm not able to convey it to you. You see this Gambura, please see his age, 25 or 28, somewhere like that.
Hmm.
Correct. So 1966 voter list, he could not see. It cannot be to his personal knowledge. And therefore, in his certificate, he certifies about the 1966 and 70 voter list.
No, he had
That-
mentioned that only, that their names also appear in the voters list. Voters papers were shown to him. On
Correct.
the basis of he has
So
given this
therefore, he has
certificate.
presumed.
That can be presumed, Lord, yes.
That has been,
But
this is a
That
presumption.
he is a resident, my lord, that is apparent from the certificate. That he is not disputing that they are not residents.
I have not heard, I have not heard that argument before this court, but elderly people tell me that there was a very beautiful argument made by one of the stalwarts here regarding to a twin baby in court number 1. I think you must be aware of it. The argument was that test tube and two marble. You have heard that story? Amongst twins, who is the oldest? Was a question which arose here before our times.
According to medical year, the baby which is born later is older. According to medical
No,
science,
we don't know, but there's a
the baby which is born later.
elderly
older.
lawyers told us that in court number 1, a issue came with regard to the twin baby, and he demonstrated by the learned counsel. I forgot. I may be wrong or right. I don't know. I was told that Dr. Jagdish Mehdi made an argument, taking a test tube and two marble,
Marvels.
and says that the second one would be the older.
No, according to medical science also,
No, that's-
second one is older.
No, that's right. So that's a presumption. When you are referring to this presumption, say that came to my mind. That we are merely presuming.
No, on the basis of the documents, he stated this, note below is. He stated, প্রকাশ থাকে যে উপরোক্ত নামটো ইমান চনত ভোটাৰ তালিকাত সংযুক্ত আছে। For that, he has not given any opinion.
Yeah. Internal cross examination, your lordship will find at page 48. You have cross examined also, giving evidence. Regarding 89 voter list, your lordship has seen. Here, in the evidence also, he has stated he was cross-examined and he stated to that. I have cast my vote, first vote, in the year 1989.
Just a moment. Yes.
German Commission Milot, on the basis of the evidence and the voters list Milot, produced, certified copies being produced Milot, those being public documents. They are to be accepted as true without any further proof. And the opinion of the tribunal that I could not prove my link is not justiciable on the basis of the evidence produced on record. And at this stage, I pray for, since the petitioner has already been arrested, Milord, and he is detained in
He's arrested.
detention can be at I have stated in my petition.
Okay. What is the date of his arrest?
He is arrested on 27/5/25, Milord. At page 22, I have stated.
Okay. Oh, that is
I pray
why,
for,
okay, okay.
I pray for bail. Milord.
Mr. Salia, you are relying on any case law?
Milord.
Are you relying on any case law?
No, Milord, on the basis of the facts, Milord.
Okay. Yes.
Facts are
Mr.
clear.
Sharma. Just a moment. Just a moment. Yes, please give again. Date of order. Yes.
Apart from that, there is a legal part about the record on, apart from Gaura, except Gaura, the evidence from nothing is here of it, and Gaura evidence totally based on Reddy law. And if it is Gaura evidence of this one, you cannot do this just with this law.
Yes.
Eleven, 12, 13, 14. On behalf of one.
TV repeat number?
Bill number 5027
As your 2020?
5027. Civil bill number 5027 2024.
Date?
Date. Date of judgment. April 2024, Lordship. 18th April 2024. And Lordship. Apart from that, Lordship. Para 26 of the Bhavananda Sonal's case, Lordship. Clearly states that May I read Lordship? There is good and sound reason for placing the burden of proof upon the person concerned who asserts to be citizen of a particular country. In order to establish one's citizenship normally, he may be required to give evidence of his date of birth, place of birth, name of his parents, and their place of birth and citizenship. Sometimes the place of birth of his grandparents may also be relevant, like under section 6A1B of the Citizenship Act. On this fact would necessarily be within the personal knowledge of the person concerned and not the authorities of the state. After he has given evidence on these points, the state authorities can verify the fact and can then lead evidence in rebuttal if necessary. If the state authorities dispute the claim of citizenship by a person and asserts that he is a foreigner, it will not only be difficult but almost impossible for them to first read evidence on the appropriate point. This is in accordance with the underlying policy of section 106 of the Evidence Act, which states that when a fact is especially within the knowledge of any person, the burden of proving that fact is upon him. And Lordship, here in this case, Lordship, if we go by the evidence of DW1, Lordship, page 48, Lordship, I was born in Katumara Nonke. My father and grandfather were also born in Katumara Nonke. My
Which-
grandparents,
Which page?
page 48, Lordship.
48.
My
Yes.
grandparents' names are Pierre and Moina. My parents' names are late Karamali and Kulsanata. I do not know whether my grandfather have any siblings or not. My father has one brother, namely Hyder Ali. We are 8 brothers and sisters, namely so and so. I got married to Sabia Khatun, and I have 5 children, namely Hamida Begum, Hamila Khatun, Halima Khatun, Saddam Hussein, and Saiful Islam. My father died in 1979 and my mother died in 2016. I do not know whether my grandfather has cast his vote or not. But my father, along with my mother, cast their vote from Kasumara Nonke and Mondira NC since 1966. Due to repatriation, my family members shifted from Kasumara Nonke to Mondira NC in the year 1978. I do not have any permanent land in Assam, and we are still living in government land. Lordship, person who deposed at DW1 concerned proceeding, Lordship, he do not know about his grandparents, Lordship, which is more important, Lordship, as per section, as per paragraph 26 of the citizenship, Sarbananda Sonowal's case, Lordship, one's case. And and Gaubura Lordship, who deposed before the tribunal, Lordship, he was become in charge Gaubura since 2017. And what he have stated that I have collected all the information, page 52. I have collected all the information about the people of our village and maintained a population register book. I have no personal knowledge about the opposite party as I was born later to the opposite party and I am 25 years old. But I know that the father of the opposite party cast his vote from my village. I have issued a Gaubura certificate only depending upon the voter ID card of the opposite party. I have carried the counter folio of the state certificate. I do not know about his mother
and name of his wife. It is not a fact that above statement and documents are false and fabricated. L- Lordship, so only on the basis of voter ID card, Lordship, he has issued this certificate, Lordship. And in the foreigner's case, voter ID is not an admissible document, Lordship. So regarding that, Lordship, so many decisions has been passed by the honorable court, Lordship. And law has been settled in this respect that Lordship, Jabura's evidence on the basis of personal knowledge cannot be accepted as a valid piece of evidence, Lordship. And Lordship, apart from that, Lordship, 1966 and 1970 voter list, Lordship, this is of village Kasumara non-K, and after that, Lordship, there is a huge gap up to 1989, Lordship. So there is a lack of continuity as per section 682 of the Citizenship Act, Lordship. And Lordship, in 1966 voter list, Lordship, one colonelist named appeared, Lordship, at the age of 50 years. And after that, Lordship, after 1970, Lordship, Alimuddin the proceedee name appeared at the age of 27 years. And Lordship, here projected father's name was reflected as Koram Ali. Koram, Lordship, not Kada, not Karan. Not Koran Ali, Lordship.
This mistakes in this name we may omit because of the recent judgments of this court.
Apart from that, Lordship, village name is different, Lordship. It's from that, Lordship.
Anything in reply? Anything in reply?
Yes, ma'am.
Yes.
Regarding the delay point, Learned Friend has referred to two judgments of the apex court and your lordship's own judgment of this court. Here, in the judgment of this court, my lord, my submission will be that their delay was considered only basis of the evidences and records of the lower court, FT court. Because there were different dates. He has taken leave and other things that were explained from 16 to 18. And this facts weighed because your lordship has referred to that at paragraph 18 of that case, the American judgment. Martin Luther King Jr.'s injustice everywhere. And there
you have not agreed with that only because of these facts. That's
In,
why
in order to tackle this Martin Luther King statement, in response, I have used used a statement
yes.
made in the movie of James Bond. You'll find it there.
Yes. So that's why, and for that reason, Milord, and there was only question of legal right there. But here my right will be constitutional right. And in the Supreme Court also, that was a question of regarding a legal right, regarding settlement of a LPG distributorship. There was some delay, but here my right in my humble submission will be fundamental right under the Constitution of India. So that being so, your lordships in my humble submission will not stick to the position in that manner. And regarding my learned friends' submission regarding the different villages, that I have explained in my evidence, it is in this cross also, that we were in another village and after erosion by the Brahmaputra, we shifted to this, he shifted to this. And their parents, so their parents' names appeared in the voter list as of village Kasomari. Kasomari. That I have stated in my evidence also. And
It is there in your pleadings also, that is at,
yes, yes, in my
that-
pleadings also.
that
in
is
my
in
evidence
paragraph
also.
14 of your written statement.
Yes,
So take a note of that.
then
Okay.
in the then in my own voters list, you also will find my village is different because there I have stated also that I have shifted to another village and I have been living there. After the
That's all, Mr. Saria, because we have to rise for the other bench.
If it has further, I will make. my
No, no,
submission
it's
there.
complete. You have anything more to add? If you have any citation, give it to the court master, we'll take
Mine,
note of that.
mine,
Just indicate the paragraph numbers
mine,
in the judgment you are trying to cite.
mine.
We'll take note of that. Mr. Sadia,
Mine.
subject to whatever decision you give, if it's possible on our part to dictate the matter, then we pronounce the order, it will be released, the order will be released. If for any reason today, by today evening, we can't complete the dictation, then we'll make it CAV. For other matters, since we don't have time, please tell the court master if there's some urgency in any other matter. We'll take note of it.
Item number 44, the inquiry report has come. Malad, because on the basis of a local verification report, reference was made of a different person against the petitioner. So, my lord, we have challenged that.
Oh, yes.
The next date of evidence is on Tuesday. So it can be on Monday, my lord.
Take tomorrow. This is tomorrow. 44.
Tomorrow.
Okay. Same matter? Yes, okay. Other matters, please give it to the court master because I have to rise. Tell the court master.